Hi, I'm Russell Morgan, the founder of the Morgan Legal Group, and today we're going to talk about same-sex couples and estate planning issues. So we have a client that I met with last week who met the love of his life 30 years ago. They had been living together for the past 30 plus years, never married, and unfortunately one of them passed from a brain aneurysm. Even though in New York, as we all know, same-sex marriage has been legalized, they just never got around to it like a lot of people. They loved each other, they lived together, there was no reason that it wouldn't change anything for them, so they never did it, which became a problem at his death. As soon as he passed away, even though they had spent the majority of their life together, he was not an heir under the law. So at this point, he has no rights to collect from his deceased partner's estate. And unfortunately, even had they just been married, he would have had the right to collect as a spouse in New York, just like anybody else. So one of the major issues that same-sex couples face is they're not married, and they think that even though they've been together forever and their partner is their partner for life, the law still controls what happens at death. When all things are said and done, our client specifically now has to prove a lot more than he would have had to prove if they had just had a ceremony. It could be a religious ceremony that's still considered a marriage valid in New York, or just went to City Hall and got married. At this point, he has no right to collect from the estate of his deceased partner. So the point that we're trying to make is, when you're planning ahead, at least create wills. If you guys don't want to get married, or if it's something that you're not interested in doing, plan ahead. Do a little bit of estate planning. Create a will. Create a trust. And come to us if you have any issues doing it, and we'll be more than happy to assist.